to meet you.
I've got two.
No, and I know there's a lot. You all have a lot going on, so that's what she was just saying. It's like,
He's like 3
yeah.
weeks old.
Questions.
Did
you read that? 'Cause
Dykes. I'm the special magistrate. I'm going to call to order the magistrate docket for April 8th, 2026. We have two matters on the docket this morning. The first one is Pamela Ratcliffe. Is Miss Ratcliffe here? All right, Miss Ratcliffe, if you want to come on up. The way we do these is you can grab a seat at this table to my left, to your right, and then we'll allow Officer Ford to present. Then you can ask any questions of Officer Ford. And then I'll allow you to present any evidence or testimony you wish for me to hear, all right? Before we begin, anybody that's here to testify or present evidence today, I'm going to need you to stand and raise your right hand, please. Ms. Ratcliffe, please stand, raise your right hand. That's fine. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. You can grab a seat. All right, Officer Ford, whenever you're ready.
Good morning, Your Honor. I'm Corporal Ford with the Sheriff's Posse. I issued the citation before the court on February the 21st at approximately 12:30 while doing a routine patrol of the beach access parking lot at Dune Allen. I observed a vehicle registered to Miss Ratcliffe parked in a properly marked and signed handicapped access space, and I was unable to see a parking permit from the rear of the vehicle. I approached the vehicle and looked carefully in every possible location within the vehicle. I was unable to find a parking permit, and therefore I issued the citation according with standard procedure and resumed patrol. Some while later, on a second pass of the area, I observed people at the vehicle. I approached the vehicle to explain the citation to them. That time they produced what appeared to be a valid placard. I explained I'd already issued the citation and closed it out in the dispatch and could not waive it. I did say that I would admit to having seen it should I be asked, that she did have a placard in her possession. She said that it was in the door. I advised her it was illegal not to display it. She said she knew that, but she had forgotten to display it.
Understood. All right. Do you have any evidence you wish to present?
Yes, Your Honor.
Thank you, sir. All right, I've got from Corporal Ford a photograph of a Honda CRV license plate RNB 223, and then two additional photographs, one being from the front outside windshield and the other being from the side, driver's side window, showing no placard visible. Did you get a chance to look at these, Ms. Ratcliffe? All right. At this time, I'll give you an opportunity. Do you have any questions for Corporal Ford? Okay. And Ms. Ratcliffe, if you want to come on up to the podium, and I'll hear from you, any evidence or testimony you wish for me to consider.
Got this.
right.
Yes, I was parked there. I'm getting forgetful now in my old age. Usually my daughter's with me and she reminds me of these things. But that time I had my grandson, he was over from England. And I got to the car, I realised it was, I put it in the
Understood. So you normally drive without it because it's hanging
Yeah, well,
and
you're
distracting?
told to remove it. I've tried putting it on the dashboard, but then when I go round the corner, it goes flying and onto the floor. So then I have to poke about on the floor to find it. But I just I'm on limited income, and for me, $250 is a lot of money. So I'm very sorry, and it's the first time that this has happened.
Right. And I believe, Corporal Bond, Corporal Ford, rather, understand that, he has to look at what he has in front of him at the time, so.
Yes, I quite understood.
Right.
We had quite a chat, actually. I've found out, can I buy on the, what's it called, the license
Right.
plate, can I have one with a sign on it?
I think that's a possibility, but you'll have to go to the tax collector's office
Right,
to
because then
do
it
with
won't
that.
be up to my forgetfulness now.
Understood.
Yeah.
It comes for all of us. I
Yeah, I
have
know.
it too.
Yes.
All right, anything else?
No,
All
that's
right,
all.
Corporal Ford, do you have any questions for Ms. Ratcliffe?
No questions, Your Honor, but I would like to close closing statements. There's quite a bit of concern that valid citations are costing us time and resources that the county. I understand the forgetfulness of the nature. The ordinance is quite specific. It does not mention anything about whether or not the defendant has a permit. It says section 2 is unlawful unless such vehicle displays a parking permit. There's also several other instances in state statute that require a penalty for people who block the access aisle, whether or not they have a permit. So if we waive this, it would be setting a precedent.
All right, understood. And while I understand the law was written somewhat as a strict liability type of crime or infraction in this case, I do believe there is room within the law to find some grace and understand that people do forget. Having said that, I'll allow Ms. Ratcliffe, if you have anything else to say based on Corporal Ford's closing statement.
Only doing his job.
Okay.
Old now. I still want to drive. But if I can buy a number plate with the registration.
All right. Thank you, ma'am.
Thank you.
All right. At this time, I'll close the evidence portion of this hearing. I'll make the following findings. Based on the testimony and evidence presented, I do find that the evidence presented and based on the admission by Ms. Ratcliffe that there was an infraction. However, I do also find that there was a valid placard that was not properly displayed. Based on that, I'm going to order that there was an infraction found in the violator was the violator is found in violation of the infraction as charged. Instead of the $250 fee, I will reduce that to $100. The clerk administrative fee of $50 will also need to be paid for a total of $150. And Ms. Ratcliffe, can you pay that within 30 days? Or would you need more time? 30 days? Okay. All right, so Ms. Ratcliffe, you'll need to pay $150 within the next 30 days, and you'll get a copy of the order, and I think it'll be in by later today?
Yes, sir.
Okay, so by later today, you can go to the clerk's office and pay that, or just pay it, as I said, within the next 30 days. All right, best of luck to you, ma'am. Thank you.
And Your Honor, that's my only case, maybe.
Yes, sir, you're excused. Our next case is Michael Varnes, V-A-R-N-E-S. Is Mr. Varnes here, or someone on behalf of Mr. Varnes? Okay. Officer Knudsen? Good morning.
Parking Enforcement Officer Nicole Knudsen. On 3/14/2026, while on patrol, I observed a white low-speed vehicle bearing Florida tag LJDQ64 parked outside of a marked parking space in violation of 20-12B1 within the Ed Walling Regional Beach Access Parking Lot. The area where the LSV was parked is clearly designated as the tram stop with the words and hash marks painted on the ground. I photographed the vehicle and ran the tag through the TLO XP system, which returned a registration to Michael Varnes of Santa Rosa Beach. Citation CE 07257 was completed. However, the low-speed vehicle departed prior to the citation being placed on the windshield. The citation was subsequently mailed via certified mail to the address listed on the vehicle registration. As shown in Exhibit 1, the words tram stop are clearly visible, along with white hash marks indicated a no parking.
All right, and do you have any evidence you wish to present? All right. All right, so I have exhibits 1, 2, 3, 4, and 5. Exhibit 1. So, Officer Knudsen, you're talking about which
It's the
one?
one on the right.
So the far right one? Okay. And is it, so these aren't parking areas, this is supposed to be
Just for
striped
the
off?
tram to come in, yes,
Right.
sir.
Okay. Now, immediate on this photograph, the second spot over, those are
That
valid
is an
parking
actual
spots? Okay.
parking space, yes, sir.
So the ones with the lines horizontal, closing off the two parallel lines, that indicates that's not a parking
sir.
space? Okay. And so as you were writing the citation, the vehicle had left?
Yes, sir.
All right. And you were able to find out the owner through searching through DMV records?
Yeah, the TLO XP system that we use.
Okay. Have you had any communications with Mr. Varnes? Did he respond after receiving
I
the?
have not.
Okay.
spoken with him.
Now, is it normal, does Mr. Varnes contact the clerk's office to request these hearings, or is it
Yes, sir.
automatic that they?
No, sir, they
Okay.
contact us.
I was just curious since if he requested it. Oh, and I do have an Exhibit 6, which is a printout of the ordinance related to parking spaces. Okay, so I'll accept Exhibits 1 through 6 into evidence. right, is there anything else? Officer Knudsen? All right, thank you, ma'am. I didn't see anybody come in. All right, so Mr. Barnes has failed to appear. I'll go ahead and close the evidence portion of this hearing. I'll make the following findings of fact and conclusions that that based on the testimony and evidence presented this morning, there has been sufficient evidence to show that a violation occurred, that based on that, I'll find that the violator is found in violation of the infraction for illegal parking. The fine imposed will be at $100. There's a clerk administrative fee of $50, as well as a clerk processing fee of $25. Has that already been paid? Okay. So the total will be $175, and Mr. Barnes will have 30 days to pay. All right. Yes, ma'am. I believe that's all that we have on the docket, so we'll go ahead, unless there's anything else, we'll go ahead and adjourn. Thank you. Yep. All right. All right, it's 10 o'clock. We're going to start here in a moment. We got a couple more people signing in. If you have a cell phone, go ahead and turn it off or put it on vibrate, and we'll start in just about a minute or less. All right, it's 10:02. I'm going to go ahead and call to order the April 8th, 2026 Code Compliance meeting to order. My name is Hayward Dykes. I'm the special magistrate that will be hearing the code compliance cases this morning. If you have a cell phone, as I stated earlier, please turn it off or put it on vibrate. If you can stand, please stand with me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You can be seated. Signed the minutes from last month. Are there any announcements regarding the agenda for this morning? No announcements? Oh, right.
Brooke Davis on behalf of the county. On number 5, CE 25-01816, their attorney's office has reached out and requested a continuance on the case because their client is not available today. We, the county, have no objection to that continuance to the May docket.
All right. Is anybody here for that case, CE
Yes.
25? All right.
There is an attorney from Dunlap and Shipman that is present. Addie, I didn't catch her last name.
Hey, Tone.
Okay. You represent the property owner?
Yes.
Okay, so you're fine with requested continuance? Seems like everybody's on board. Is there anybody else here from the public that was here for this particular matter? Okay. If there's no objection, then we'll just continue this to the May 13th agenda. All right,
Great,
thanks,
thank
guys.
you, Your Honor.
All right, no more announcements. All right, without there being any other announcements, at this time, anyone who plans to testify or speak on any of the matters here before us today, if you'll please stand and raise your right hand, I'll go ahead and swear everyone in at one time. All right. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you all. All right, and just for those who may not know, what we'll do is when we call the case, if you're the respondent or the property owner, you can come up and sit to my left at that long table. We'll allow the county to present their case. You can ask questions of anyone from the county that presents testimony or evidence, and then I'll hear any testimony or evidence that you may want me to hear on the matter today. So with that having been said, our first case on the agenda is BCHV 2600218. The business name is Destin Beach Bonfire, and this is for appealing the suspension of a beach vending permit. Is there anybody here for this? All right. And if you'll, whenever you approach, we do record these, so whenever you come to speak, you'll need to come up to the podium and just state your full name so we have that for the record. All right. So this is an appeal from property owner Kaylee Voiles. Am I pronouncing that? Are you Miss Voiles? Okay. All right, and then who do we have for the county?
My name is Officer Coberling with Beach Code Compliance.
How do you spell that?
Coberling, Koberling.
Make sure that microphone's on. Is that on?
Hello? Yes.
All right, Officer Coberline, if you want to go ahead and present on behalf of the county.
Yes, sir. At approximately 3:34 p.m. on February 22nd, I performed a bonfire inspection at Scenic Gulf. Thank you. For Destin Bonfire Company. The vendor in charge met me in the parking lot, provided 2 permits for the 2 fire pits at their event. He stated he had to get more supplies and left other employees on site to finish up. After checking the fire location, we noticed that the second permit was not listed on our DES website. Upon further investigation and research, we found that the second permit had expired the same date of the prior year, February 22nd, 2025, and was no longer valid. So the following day, we issued a citation CE 05277 to admin to be mailed out and notified the vendor. On February 24th, the subject admitted guilt by paying the citation. So the county recommended the 3-day suspension beginning 3 days after today's date. Or sorry, my apologies, 48 hours from today's date for 3 days.
All right, and then, do you have any evidence you wish to present, or
Not at this time,
Okay.
no, sir.
all right, Miss Voiles, do you have any questions for Officer Coberling? Okay, at this time, if you want to approach, I'll hear any testimony or evidence related to the appeal of the suspension.
It was an oversight issue on our end, and we have put in different procedures to make sure it doesn't happen again. And there was issues with the emails, and so I had gotten confused because typically the fire department, if you have a special event permit, if it's over 2 weeks out, they send a fire permit to the email, but we were having issues receiving any fire permits. So we had 2 bonfires at night for the same special event. So I had purchased one, and then I thought they had sent one like they typically do. So when I went in the email, I just typed in 222, but I didn't look at the year. So that's what happened, and I just screenshot it, sent it, and then I didn't realize that it was for the previous year.
So, all right, so you're requesting that the suspension not be imposed? Okay, hold on one second.
Your Honor.
Okay. And if you want to come on up, what's your name, sir?
Eric Severin, with Destin Bonfire Company, and also consult for a few other bonfire companies in the area too. But yeah, we were requesting that the 3-day suspension be upheld. We'd be more than happy to pay any sort of fine, and we do employ about 10 to 20 high schoolers in the area. So, shutting the business down for 3 days would not only hurt their income with, making their car payments and things like that, but also hurt our business too. We've also been doing this about 4 or 5 years now. So, yeah, that was the reason for the hearing today.
Right. I'm sorry, did you get, what's your last name, sir? I'm sorry.
Oh, Severin.
Severin, okay. Understood. I don't know that I have the ability to impose another fine, right? So you've already paid, and there's no, the code doesn't provide me a mechanism or a carve out to say, hey, if you pay this, then you can waive the 3-day suspension. It's basically automatic at this point, unless there's extenuating circumstances. Is there any reason why, if the suspension is not imposed and started immediately, that would minimize the impact to the business?
There's pretty much bonfires every day going on at this point, with spring break and then summer right around the corner. So yeah, it would definitely negatively impact the business and the employees.
And I understand that, and I think that's kind of part of the stick in the code. And I don't, I'm not in that business or in that space, so I'm trying to think of a way to minimize impact to your business. If it's done during the weekdays, maybe you have less, permits or bonfire events. because as I said, I think my hands are tied as it relates to that, but I'm willing to try to work with you to try to minimize, like, hey, if we do it Wednesday, Thursday, Friday, that's gonna be less of an impact to my business versus a Friday, Saturday, Sunday.
Yeah, definitely. I mean, Monday, Tuesday, Wednesday might be a lesser impact compared to the weekend. But is there any way to mitigate the 3-day suspension? I mean, the only way to really not affect the business would be to do it in like winter or some sort of off-season time, something like that.
No, I'm not willing to do that. I mean, I can't just, put it off. Like I said, I'm willing to try to take some of the sting out, but I mean, I can't just, set it off and let's find out when you're not doing anything and do it. I mean, it kind of defeats the purpose of the suspension if we do that, right? So, again, I'm willing to hear anything you want to present to say, hey, instead of 48 hours, can we start it tomorrow, which would be Wednesday, and then the 3 days would run from then, but they would be 3 consecutive days. I'm not going to split it up, Tuesday this week, Tuesday of next week, Tuesday of the following week. So,
Any way to push it off at least 2 weeks? That way we can give all of the customers a bigger heads up than just the day of or the day before, so that way they could try to find a different company to go with.
I don't know. Let me hear from the county on this. All right. So if you both will grab a seat. What's the county's position? I know the county has requested that the suspension begin in 48 hours. I mean, I'm willing to consider maybe expediting that so they can go ahead and get their suspension over with, but they look like they're trying to put it off. I'm willing to consider that to some degree, but I do want to hear from the county since it's the county's, objecting, obviously.
Yes, Your Honor. Per the county's standards and SOPs, they do state that 48 hours prior or 48 hours after the date is when to start the suspension.
Okay. So which is fine. So the county's position is still the same?
Yes.
You would want it to begin within the next 48 hours?
Yes, sir.
Okay. Thank you, sir.
Thank you.
All right. Mr. Severin or Ms. Voiles, I'll hear one last word from you if you want me to consider. I will tell you at this point, I'm not willing to put it off 2 weeks, but I mean, I can either maybe bump it, start it a little later, or I can start it maybe within the next 24 hours to go ahead and get it going and over with, so you don't have this kind of hanging out there. So,
Fires every night moving forward. Even yesterday, there was a burn ban.
right. I don't know that we're going to get any more rain anytime soon. So I don't know if there's going to be more burn bans. That's what I'm saying. If you start it now and get, kind of take the medicine, so to speak, now, then it's over with. And then when those burn bans get lifted, maybe you're ready to go, versus I put it off for 48, 72 hours, whenever, and then those burn bans get lifted and you're right in the meat of your suspension. So, as I said, I mean, it's up to you. Like, I understand the county's position, and I'm willing to work with you to some degree to try to, like I said, kind of lessen the sting. But I think, as I said, my hands are tied. I mean, it's in the code as far as that goes. I don't have much or any wiggle room when it comes to deviating from it. So,
One bonfire when probably 10,000. I mean, I know your hands are tied.
right. And like I said, this isn't one where I can say pay another 700 and we'll just waive the 3 days. That's not an option for me in the code. Or I would, you probably would have just done that and not came to this hearing, right? So, as I said, either we can start it in the next 48 hours, or I can consider an alternative time. But as I said, you know, I'll give you the last word, and then I'll make a. No, I'm not gonna set it off 2.5 weeks from now. I mean, if you need a little bit of time to try to, yeah, if you wanna take a moment to look at your schedule, I can move on if it's gonna take a moment. If it's just gonna take, you know, we have a full slate of cases, so I'm trying to get you guys in and out as well as handle those others. Do we want to go ahead and just move on to the next case, and then we'll just come back? Why don't we do that? I'll go ahead and move on to the next case, because it's something I think we can probably get resolved somewhat quickly. So the next case on the agenda is CE 25-01444. Property owner listed as Amore at Gulf Place LLC, and this is a fine reduction request. All right. Yeah, and we have the applicant here for the fine reduction.
Yeah, Elizabeth Billheimer, Matthews and Matthews on behalf of Board.
Yes, Ms. Billheimer, since it's your application or your client's application for fine reduction, do you want to go ahead and set forth the basis for the request?
Thank you, Your Honor. With respect to this case, this involves the area known as the artist area at Gulf Place, so the center place with the kiosks where artists display their wares. It's been in existence for more than 20 years. But apparently I don't know if there was never a DO, but at some point my client had to apply for a less than minor development order to cover the artist area. And obviously that took some time. You know, they purchased the property in September of 22, had a active artist area until 24 or 25 when they closed it down to do some renovations. And then this issue about whether post-permit changes and the like came up. Everything now has been, the less than minor has been approved. There certainly has been no foot dragging, I think, on either side. It's just been complicated in terms of there was some time taken looking for the original development order, which would have been issued around the 2000, early 2000s period. My client does request that the county waive fees with respect to the violations. Everything is in accordance with at the moment. There's one issue with respect to the last administrative fee. I think it was like $33. I talked to Jennifer about that, and we're looking into it. Doesn't show up in the portal, but my client's obviously willing to pay that administrative fee. But we would seek a waiver of the fines that have been imposed.
And I have in my notes as of the affidavit of compliance, which was executed on or about March 6th. There's $22,000 in fines that have accumulated. I'm looking at the original order. It was $250 per day until the property was brought into compliance, and that was after about a 60-day window to try to bring the property in compliance. So the applicant is seeking to waive the entirety of the 22. Is that correct, Ms. Billheimer?
Yeah, yes, Your Honor.
All right. Thank you, ma'am. I'll hear from the county.
Code Compliance Supervisor Jennifer King. The county would recommend not to waive all the fees. We don't have a set amount, but we would like you to consider the fact that they were given reasonable time to remove the violations. That was always an option. They actually had removed most of the violations prior to the hearing date, the original hearing date. But the boat that was placed in a retention pond or retention area remained. So all they would have had to do was remove that boat until they got their less than minor approved to achieve compliance within the time frame set.
Was it like a decorative boat
Decorative,
or
yes, sir.
something out there? I think I remember.
They had already ceased operations for the season, so all the displays, the extra lighting that was not approved, all that stuff had been removed prior to the hearing. But we did get them adjudicated for the post-development order changes. But yes, and they had the cluck, they obtained the cluck as well afterwards. So again, all they would have had to do was remove the boat.
All right, so am I correct in saying the county is not opposed to a fine reduction, but reducing it to zero is not what the county would agree to?
Correct.
Okay. Understood. All right. Ms. Billheimer, do you have anything else? Obviously, you hear the county's position. I think I would tend to agree that, the fines are there, as I stated before, kind of as a stick to incentivize compliance. Otherwise, if the idea is we'll just do it when we get to it and come ask for zero, what's the, what type of teeth does it have? So, while I understand your client, I will go ahead and tell you, I'm generally never inclined to reduce it to zero unless the county provides, some basis for it. And if the county's fine with it, then I'm generally fine with it. But I'll be willing to hear anything else you have.
Yeah, we would, in light of the no waiver policy, Your Honor, we would ask for $1,500 fine.
Okay. Now, just so we're clear, it's not a policy.
Yeah, I
I'm just saying,
understand.
in
No,
general,
I understand.
it's hard,
I understand the
it's-
concept.
I'm reluctant to reduce it to zero minus extenuating circumstances.
Right.
All right, so I appreciate that, Ms. Billheimer. Does the county have any comment regarding Ms. Billheimer's request in that regard, or?
We'd recommend a 10%.
So that would be 2,200?
Correct.
Okay. All right. I appreciate both the county and Ms. Billheimer. I'll go ahead and close the evidence portion of this. Based on the testimony and evidence presented, I'll find that the property has been brought into compliance, and that based on the testimony and evidence that a fine reduction would be in order. In reference to the $22,000 fine, that fine will be reduced to $2,200. Ms. Billheimer, would your client be able to pay that within the next 30 days? Yes. Okay. And then you said we're gonna check on that administrative fee that was previously listed.
I believe the 33 was already paid, but we'll make sure of that.
Okay.
But there is an additional $23 admin fee for the recording cost of this fine reduction.
Right, I see that. So in total, Ms. Billheimer, your client will need to pay $2,223 because there is a $23 administrative fee for today's hearing. And if you're confident they can pay that within 30 days, I'll require they pay that within 30 days. In the event they fail to pay the reduced fine within 30 days, as well as the administrative fee, the fine will go back to its original amount of $22,000. All right, so just make sure they understand that. All right, any questions regarding the fine reduction? All right, thank you both.
Thank you.
Yep. All right, I'm going to call back Ms. Voiles. Ms. Voiles, have you had an opportunity to look at that, your calendar? And like I said, I'll be glad to hear one last time from you. As I said, the county, which it sounds like is their standard policy, they would have the 3-day suspension go into effect within the next 48 hours. I'm willing to consider, within a reasonable time frame if you want a different start date on that. But what would you have me here? If you don't mind, would you come up? Thank you.
You're welcome. Yes, Your Honor, we are requesting that it starts this Sunday, April the 12th, for the 3-day suspension.
Okay. Thank you, ma'am. Officer Coberling, I would be inclined to maybe have that start. You can grab a seat. I would be inclined to maybe have that start this Sunday. I mean, it is a little bit later than the 48 hours requested. Does the county have any comments on that, one way or the other?
No, Your Honor, we're good with that.
Okay.
We're okay with that.
All right. Thank you, sir.
Thank you.
All right. At this time, I'll close the evidence portion of this hearing. Based on the testimony and evidence, I do find that the 3-day, or I will deny the appeal to not impose the 3-day suspension as provided in the Land Development Code. I will order that the suspension will begin on April 12th, this Sunday. That's when you want it to start, right? On a Sunday? Okay. So it'll start this Sunday, April 12th, and will extend for the subsequent 3 days, 72 hours. All right. Is there any questions regarding the ruling? All right. Thank you both. You're both dismissed. Yep. All right. Our next case is CE 26-1623. Property owner is Barton Living Trust, and this is a request for fine reduction.
Yes, sir. Co-compliance Supervisor Jennifer King. In regards to this case, the county recommendation is to eliminate the accrued fines. The county acknowledges that the property owner has taken corrective actions to bring the property into compliance. Specifically, the portion of the porch that encroached into the required setbacks has been removed, resolving the issues that previously prevented the approval of the building of the BPR application. The county further acknowledges that evidence was provided demonstrating that the corrective action was completed prior to the established compliance deadline. Based on the property owner's good faith effort, timely compliance, and voluntary correction of the violation, the county recommends that all accrued fines associated with the violation be waived. The property owner did agree to pay the $23 admin fee.
Okay. So the county had evidence that the violation had actually been rectified, or?
Yes, she had showed evidence. We'd actually went out there and measured it ourselves that the portion of the porch had been removed back in February. The compliance due date was not until March 10th, I believe. However, planning did not approve the BPR until just recently. So she had accrued fines when she shouldn't have.
Okay. All right. And there's nobody here on behalf of the Barton Living Trust?
I told her she would not have to show up since
Understood.
we were waiving all the fees.
All right. Thank you, ma'am. Based on I'll close the evidence portion. Based on the testimony and evidence presented and the county's request, I'll order that the property has been brought into compliance and the request for a fine reduction will be granted based on the county's testimony that the property had been brought into compliance prior to the due date listed in the final order. I will waive the $2,000 in in fines that have been imposed on the property to zero. However, I will order that the $23 in administrative fees will need to be paid. That'll need to be paid within 30 days of today's date. All right. No. Next case is CE 23-2676. Property owner is listed Foreshore 30A LLC. And this is also a request for a fine reduction. Do we have anyone here? Oh. And your name, ma'am?
Sarah Stewart.
Okay. All right, Ms. Stewart, since you're requesting the fine reduction for Shore 30A LLC, I'll let you go ahead and, if you want to present.
So we were first notified of this issue as foreshore, basically not until the end of December of this year. Fines had started accruing many years ago for one of our tenants. It's a commercial building. They had not received proper clearance, I guess, with planning and zoning. But as owners of Foreshore, I've spoken to the code compliance officers many times. The address they had originally sent notification to was no longer a current address for any of the owners. So all of the notifications had been returned. But there was a call related to, it went to the fire marshal essentially in November. They thought it was like overoccupied, which they cleared it and said it was not. But they brought code compliance with at that time. And the officer, Justin, at that point sent the letter, but then he also actually looked up the correct address. So that was the first time we received it was, let's see, we got that December 30th. So at that point, we were under the impression it was just related to the sign, not having received permitting, which we actually did get that permitted. I believe it was 2 years prior. We had approval from the county. We used an approved vendor. And so Justin said he was, going to check into that, which he did. And then we received a phone call from Jennifer stating that actually all the fines that accrued were actually for sure rather than our tenant. And those dated back to, I believe it was 2024.
Yes, ma'am.
But again, we were not notified until just most recently in December. And as of that point, I feel like we've been very proactive with the county, working with both code compliance, and we had our tenant reach out to planning and zoning. And since that time, the tenant is no longer there. They left March 13th, I believe. And our new code compliance officer, Harold, has verified that the sign was removed, I believe, within a couple days of us talking to Justin back in January. So again, once we were notified, we feel like we've been very compliant. Hopefully the officers would agree we've been very cooperative since we were made aware.
Okay. I've got listed that accumulated fines, as you said, this is an older case.
Correct.
Compliance due date was in April of 2024. Shows the property was brought in compliance, or at least when the county inspected the property and found and signed the affidavit was March of this year.
Correct.
693 days days for the fines to accrue, so we're at 69,300. What are you asking for the fine reduction to be?
I mean, ideally 0, but I know that sounds like that's not an option.
That's fine. I mean, you can ask for 0.
No.
I mean, you know.
Exactly. So, and I know the original fine, I believe, was $5,400. Again, we did not know about this
Right.
for essentially year and a half. But I mean, I feel like maybe the original fine amount, $5,400.
Okay.
Again, I would say very cooperative the second we found out, and if anything, probably aggressive in our follow-up with
Understood.
code compliance, so.
Yeah, I understand. And sometimes it takes some time, and that's why we have this opportunity for people to come
Yeah.
in and
Which we appreciate.
make these requests. So, all right. So at this point, if not 0, you're requesting 5,400. Is that correct? All right. Thank you. Who from the county is going to speak on this?
Officer Harold Serrano. As Ms. Stewart did say that she did make ample attempt to get this cleared up, would like to notate that there is some confusion out the most recent case they had recently gotten compliance with, and this particular case, reaching 3 years in non-compliance. There was traffic when I took over for Officer Sloan, that there was communication. So at this time, we would have no recommendation for a fine reduction due to the traffic that I had observed, and with the time lapse of it, nothing had been done, even with communication of said violations. So I think the matter is the confusion of the two cases at the time of the most recent one had gotten in compliance so swiftly that we believe that there just was a neglect of getting it in compliance over the 3 year period now.
So are you saying there were multiple, code issues and one was resolved earlier?
Yeah, so this case, particularly the 3-year-old case, was a cluck violation. The most recent one was a development approval. Similar reaction to both of them for compliance. However, the most recent case had gotten complied on March 13th. But the neglect of that, not being so swift on that case, we really have no reason to give them a fine reduction or a recommendation due to the fact it was done so fast. There was still ample time for them to know about the 3-year-old case. So at this,
Right, and I mean, I'm not here to handle the one that, or the more recent one that you're
Right.
speaking of. We're just here to talk about the one
correct.
that's.
I just put it in a
3-year-old.
context of that's why we have no fine reduction recommendation.
Oh, okay, so, I mean, sounds like they had another issue that appears to have been resolved. That's great, but as far as this goes, the county doesn't have.
We do not at this time.
Are you opposed to a fine reduction? I mean, I understand that it's taken some time to get us here, but I mean, is the county just strictly opposed to a fine reduction?
At this time, we have no recommendations.
Right, I understand. So you don't have a recommendation for fine reduction or not, or are you just saying no recommendation on an amount?
No recommendation on amount.
Okay, so you're not opposed to the fine
Not
reduction?
opposed, no.
You're just saying.
We're just not, we
you're
don't
not
have
gonna
a,
give
we have a
number.
recommendation on an amount.
Okay, understood. All right. Thank you, sir. All right, Ms. Stewart, I'll give you the last word if you want to add anything else.
I mean, I can just add something briefly. So, he's referring to I guess maybe that's where there's some confusion. So the cluck was actually for one of our tenants. It wasn't us as an entity, the people that own the building. And so when they notified, it was a school that was trying to get permitting, they never notified us about any of these issues. So that's where we, as the owners of the building, were not notified until just December, most recently. So,
Okay.
and they referenced it, it was kind of accidental that it even came up. We had no idea that they had filed this lien against our building, because of the fines, et cetera. So this was literally our first time hearing about
Okay.
it as the owners of the building,
So because of that violation, that's when this one kind of popped up.
Exactly,
and
it
you
kind of
said-
started popping up. It feels like
Okay.
more and more things then just kind of popped up, so.
Understood. All right. All right, thank you, ma'am. All right, I'll close the evidence portion of this hearing. I will state that, we're notwithstanding another code case, that's not before me today. I'm just looking at strictly case number 23-02676 and what's accumulated over the time. I do find that based on the testimony and evidence and without objection from the county, a fine reduction is appropriate based on this case. Due to the amount of time and the years that have passed, while I do find that it's been some time, what I will do is reduce the fine to $6,930, which is 10%, which is generally in line with what the county is acceptable with, as well as myself, assuming there's no extenuating circumstances. I know that's a little more than what you requested, Ms. Stewart, but I think that that is appropriate considering I don't know that this would have been resolved but for the other one. But I am glad to see that this one is getting resolved as well. Ms. Stewart, I do have a question for you. Would there be any problem with your client or the company being able to pay this within the next 30 days, or would you need a little more time? No. Okay. All right. So at this time, I'll order that the fine that's accumulated of $69,300 will be reduced to $6,930. Should that amount not be paid within the next 30 days, the original amount of $69,300 will be automatically reimposed. There's also an administrative fee of $23, similar to the last one you may have heard, so that'll also need to be paid as well within the next 30 days. All right. Are there any questions regarding the fine reduction? All right. Thank you. All right, the next case we have, we continued number 5 on the agenda. We're going to number 6. That's case number 25-01948. The property owner is listed as Jose Matias, Matias. Is there someone here for Mr. Matias? Right? And what's your name? Okay. Is that your first name or your last name? What's your last name? Okay, so, and you're here on behalf of Jose Matias? Okay. And who are you? Are you the daughter, wife? What are you? Okay. So you're also the owner of the property? Okay, thank you, ma'am. All right. Make sure I got the right file. All right. Is your middle name?
Oh, my last name is Matias.
Oh, okay. So it's hyphenated?
Hyphenated, yes.
Oh, okay. I'm sorry. That's where I was confused.
I was also.
Okay. I'm sorry about that. All right. All right. I've got the file. Whenever you're ready, go ahead.
All right. For the record, I'm submitting my final summary report, presentation, and testimony in reference to case number 25-01948. Properties in the unincorporated area of Walton County, subject to the Land Development Code, Chapter 7, located at 157 East Harborview Road, Santa Rosa Beach, belonging to Lorenzo Matias Jose. Violations listed is 1.308, post-permit changes, 1.1309C, building permits, 7.02.01A, junk and litter. On 12/2/2025, the complaint for potential remodeling without a permit was received with initial inspection completed and a stop work order issued on 12/4/25. And the stop order was issued to verify with building department if a permit was needed for the remodel activity. I also observed a covered rear deck, a shed on the west side of the property appeared to be in setbacks, along with a debris pile matching the interior remodel activity. On 12/6/2025, I received a confirmation from the building department that no permit was needed for the interior remodel and lifted the stop work order. On 12/10/25, notice of violation was placed in certified mail for the needed planning approvals and potential permit for the shed and covered deck, then posted the property on 12/11/25. On 1/7/26, a follow-up showed minimal progress, but a pre-application had been placed in portal for a meeting scheduled on 1/20/26 with planning. Follow-ups continued with progress of the initial debris being removed and the shed relocated to the east side of the property. But still had not been I hadn't had any direct contact with the owner, and I hadn't seen any type of planning approvals being made. On 2/21/26, I received phone contact from Miss Lorenza discussing the situation and the need for the planning approvals and the potential setback issues and the deadline of compliance. On 3/30/26, the notice of hearing was placed in certified mail, along with being hand-delivered to Ms. Lorenzo's mother, with affidavit of service being added to the case file. And I did speak with Ms. Lorenzo on the phone that day, advising of the posting. And then on 4/7, yesterday, inspection showed the violations continuing to be present. I would like to submit my packet into evidence.
All right, I'll accept the county's packet into evidence. Has Ms. Matias Jose received one? Have you received a copy of this? Okay. Do you have anything additional Officer
No,
Forehand? Okay. Do you have any questions for Officer Forehand regarding the testimony or the evidence that he's presented this morning? Okay. All right. Ms. Matias-Jose, if you, am I saying, is Matias-Jose? Yeah. Okay, good. Ms. Matias-Jose, if you want to approach the podium, I'll be glad to hear any testimony or evidence you want me to consider this morning. Well, hold on. Yeah, wait till you come up here. We do record these, so that's why.
When I said that whenever I bought the house, the shed is already there. So I try to like contact with my realtor and see if she has like any papers or anything to prove that that shed is been there when I bought the house. Because I bought the house on October the 10th. That was the last time when I signed for the house. And then my neighbor told me that that shed has been there more than 10 years when he moved there with the neighbor.
Okay. So are you attempting to get a permit related to, or approval related to the shed still? Okay. And then what about the junk and litter that's also alleged? What is the status of that?
It's already picked up. It's all cleaned up.
Okay. So how long do you think it, you know, and this might be a better question for the county, how long are we thinking you might need to bring the property fully into compliance, assuming the junk and litter has been picked up? You know, they can come out and check that out pretty easily. Seems to me like the holdup might be getting approval for the accessory structure of the shed and where that needs to be located. How much time do you think it would take for you to maybe get that through the county process?
I would need like a lot of time because I work and I really don't have time. I'll say maybe more than 30 days.
Okay. Let me ask Officer Forehand. All right. Anything else, ma'am?
That's it.
Okay, thank you.
Thank you.
Officer, well, hold on one second. Officer Forehand, do you have any questions for Ms. Matias-Jose? Okay. Do you have any insight on where we might, as far as the timeline goes for considering, you know, it sounds like she's applied, but they haven't.
Yeah, they tried to make a couple of attempts, and it was the improper ones, and they got refused in the portal. And I think there was just a bit of communication and confusion with how the portal works. And I suggested at least 60 to potentially 90 days because I know it is confusion in that portal, and she may need to re-meet someone there at planning to kind of enter through that process.
Yeah, that's what I was leaning towards, giving her a little more time. It doesn't sound like any of these are immediate health, safety, and welfare issues
No, sir.
for her or the community. It does sound like she's attempting to go through the process to at least try to keep that accessory structure. And you heard her testimony today, the junk and litter may have been resolved, so that'll just
Yeah,
take
what's
a
there
follow-up.
now is a little bit of construction debris where they've been doing some updates to the front porch, which is allowed. And it's just a general cut off from the extra lumber and stuff that could be like tucked away either in the shed or somewhere. For that zoning, you know, anything out there that's exposed is considered for under Chapter 7, kind of needs to be tucked away or out of sight and just picked up and not out in public view there.
So, having said that, I mean, that to me seems like something that can be resolved
Oh, yeah.
more quickly than
Yes,
the
sir.
others. So, I mean, I'm inclined to maybe give 30 days to resolve the junk and debris, but then give a longer time for you to try to get your permitting completed through the county. But would there be any problems splitting it like that, or would you just prefer they all have the same?
Under one hat would make it a lot easier on our process of the affidavit of compliance.
Understood. All right. Anything else?
No, sir.
From the county? All right. Ms. Matias-Jose, do you have anything else you want me to consider? All right. Thank you both. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 157 East Harbor View Road in Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that based on the testimony and evidence presented this morning, I do find that the conditions exist to show that there is a violation at the property, specifically a violation of 1.13.08 post-permit changes, 1.13.09C building permit requirement, and 7.02.01A junk and litter. What's the county's recommendation regarding fines?
I put it as $100 a day with administrative fee $73.
All right, thank you, sir. I'll find that the property needs to be brought into compliance within 90 days. What's 90 days from today?
It's going to be
July 7th? All right. So the property will need to be brought in compliance on or before July 7th. That's approximately 90 days from today. Should the property not be brought into compliance on or before July 7th, a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That fee will need to be paid within the next 30 days. Ms. Matias Jose, do you understand that you have until July 7th to try to get your permit? Also, this is all of them, so even the junk and debris, if you get everything done early, go ahead and call the county so they can come out, check the property and confirm you've got your permit, your building permit, and then they can wrap that up. The $73, as I stated, that'll be paid regardless, so even if you get everything done tomorrow, you still have to pay the $73. You understand that? Okay. Do you have any questions regarding the order? All right. All right. Did I miss anything, Officer Forehand?
Seems to be good.
All right. Thank you, sir. All right. I've signed that order. Good luck to you, Miss. Thank you. All right. Our next case is 25-01942. Property owner is listed as Erica Rice. And do we have anyone here for Miss Rice? Oh, okay.
Your Honor, Brooke Davis on behalf of the county. At this time, it's my understanding that the property owner has retained an attorney, Mr. Daniel Ufelder.
Okay.
In preparation of their case, they had attempted to do a public records request. It appears that public records request went to the clerk's office instead of going to the county attorney's office, so that has not been fulfilled. So they're requesting a continuance, and the county would have no objection to that.
Are we just looking to next month?
Yes.
Mr. Ufelder and Ms. Right.
Agreeing to next month.
Okay. I mean, if everybody feels like that's,
The public records request was sent.
well, like I said, I mean, if we want to go further, and both sides agree, I don't mind bumping it till then. I do, what I don't want to do, or I'm hoping to avoid, is that we get here on May 13th and you don't have everything, or, we're asking for another one, but.
I think the county's request is a 1-month continuance. We would be in agreement with that. Further than there, I don't think we're in a position to make that agreement today.
Okay. Well, let's do that. Let's just do it for the 13th. Everybody cross our fingers that there's not a bunch of documents out there that need to be sorted through. And then if you need another one, we'll deal with it at that time. So, without objection, and at the request of both the county and the property owner, Ms. Rice, we'll continue this matter to May 13th. All right. Good. All right. Excellent. Thank you both.
Thanks. That's all I have.
All right, thank you. All right, our next case is CE 260017, and the property owner is listed as Giovanna Lopez. Is Miss Lopez here, or someone on behalf? Are you Miss Lopez? Yes. Okay. All right, Officer Neenan, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regards to case number 26-00017. The property is located at 245 East Violet Lane, Phoenix Springs, Florida, 32433. Property owner is Giovanna Lopez. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and the county ordinances. The violations cited are 1.13.00 development approvals and 1.13.09C building permits. On January 12th of 2026, our office received a complaint stating that there were structures on the property without permits. On January 16th of 2026, Officer Sloan conducted an initial inspection and found 2 structures that exceeded 400 square foot and 2 pole barns without permits. On that same day, a notice of violation was given as prescribed by code. On January 22nd of 2026, contact was made with the property owner and the violations were discussed with them. On February 3rd of 2026, I conducted a follow-up inspection and was able to see that 1 shed had been removed off the property and that the other yellow shed had been moved out of the setbacks. On March 2nd of 2026, the property owner applied for planning approval. On March 3rd of 2026, I conducted a follow-up inspection and found that the second shed had been brought back but was not in the setbacks. On March 19th of 2026, a notice of hearing was given as prescribed by code. As of today, the property owner has not submitted the necessary documents requested from the planning department for approval. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right, that'll be accepted into evidence. So you said they have not submitted an application, or they did submit an application?
They have, they also have a tiny home on the property that has been given a planning and building permit.
Okay.
But all of the other accessory structures, they're doing an addition onto the tiny home. So they've enclosed a pole barn that is going to be their bedrooms and stuff. And from what I've been told is that they were going to do a connection in between the 2 buildings. But the planning department is waiting on clarification on what they intend to do with those buildings, if they intend to combine them, if it intends to just be the carport, a pole barn, another accessory structure that's not going to be lived in, and then the 2 sheds as well. There's multiple structures on this property.
Right, so I see in Exhibit 18 of what you presented, there's a BPR plan review.
Correct. That's for the carport, the 2 sheds, the addition to the tiny home, and the other pole barn.
All right, so all we're dealing with today, so I'm clear, is just the accessory structures and the pole barn, correct?
It'll be both sheds, the carport, the enclosure that they could be connecting to their tiny home, and another pole barn.
Right, but I don't see that. Have they made the connection?
They have not made the connection as of right now, but they are living in that bigger structure.
Okay. Well, I guess what I'm getting at is, how can I cite them for something they haven't even built yet? I mean,
It's built.
the breezeway or the connector.
Right, that's what they're applying for right now, is whether or not because they're living in it, they don't have an accessory, a second, I don't know if they're even allowed to have 2 accessory dwellings on the property. And that building inside of it does not have the necessary qualifications to be qualified as an accessory dwelling.
Right, but that would be covered under your violation for development approval and building permit requirement, right? Because if they're not allowed to have the multiple accessory structures on that property.
Correct.
Then they'll be told, hey, you're not getting permits for that, you're gonna have to
Right.
remove them. So I think that would be covered under that. I guess what I'm getting at is I don't wanna suggest that I can cite them for something that they haven't built or that's not out there, and they're talking about we may build it, because if they don't get a permit to build this breezeway or walkway, then I don't know that would also be covered under no permit, correct?
Correct, yes, sir.
Okay.
So whether they decide to connect it or not, they would still need a permit or development approval for that building, just deciding on whether it's going to be connected to the tiny home or not.
Right. So I guess my overall statement is, regardless of where they build that walkway or not, or they have these accessories, multiple, or they're allowed to have, it's all gonna be kind of, figured out in the wash when they seek their permitting and
Correct, yes, sir.
all right. All right. Anything else, Officer Neenan?
No, sir.
Okay. Ms. Lopez, do you have any questions for Officer Neenan regarding her testimony? Okay. Come on up. Raise your right
I need to
hand.
be sworn in
Yeah,
too from the beginning because
That's fine. I'll swear you in. Do you swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
And then you plan to help interpret for Ms. Lopez?
I do.
Okay, so do you swear affirm to accurately and truly, to the best of your ability, translate on behalf of Ms. Lopez for this hearing?
I do.
All right, thank you, sir.
Hmm?
All right. Ms. Lopez, still ask her to come up. All right, Ms. Lopez, I had asked, does she have any questions for Officer Neenan, or did she understand what Officer Neenan testified to?
Si le tienes preguntas a la señora sí, por lo que he dicho.
Oh, you want to ask?
¿Estabas aquí en el principio cuando nos...
Sí. Cuando...
No, desde el principio, cuando comenzamos todo.
No.
Okay, she wasn't.
Estaba en otro edificio buscando ya.
Okay.
Ask her to raise her right hand.
Si puedes levantar la mano derecha.
All right, and just as best you can translate, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Que prometes decir la verdad hoy.
Sí.
All right, thank you, ma'am. All right, did she understand to some degree, or do you need to translate the violations that are currently pending? I want to make sure she understands.
Sí, entiendes las violaciones que tienes en la propiedad.
Sí.
She understands the violations.
And so she understands that the claims, at least at this point from the county, are you have at least 2 accessory structures that have failed to have permits or approval through planning, as well as the, I guess, pole barn that was also constructed. She understands that those all need permits and approval from county.
Que entiendes que hay 2 estructuras o 3 estructuras que no tienen permisos en la propiedad.
Solo hay una. Una tiene permiso.
I can show 'em. No, you're fine.
And I've got an extra packet if you need one.
Back here would need to be permitted. This carport would need to be permitted.
Las estructuras que estamos mirando aquí sería esta, el pole barn y estas 2.
Estas 2 son movibles, son mobile homes.
Ajá.
Son movibles.
Sí, sí, pero todavía necesitan permisos. O sea, necesitas
Son storage.
Claro. Ajá.
Oh, okay.
Ajá. And this is on, where's this property? In Definiak?
Yeah.
Okay.
So this is gonna have to be moved out of the 20-foot setback, or
Okay.
front setback. It's gonna have to be moved. There's a pole barn back here as well behind
Oh.
there's 3 buildings here. So that pole barn back there, then there's the tiny home in the middle, and then this building that they're building now that they're living in. So that one, and the 2, and the pole barn in the back would need to be permitted.
Okay. Okay. Bueno, dice que porque hay unas que necesitas moverlas porque están en lo que nosotros decimos son los setbacks, que normalmente son áreas como me dijo que esta está a frente de la casa. Esta.
Sí.
Y hay 25 pies de la propiedad para adentro que no puedes tener nada en ese lugar. Y luego aquí atrás dice que hay como 3 estructuras que también necesitan permisos y estos 2 también necesitan permisos, aunque sean simplemente para storage, también necesitas aplicaciones y permisos para las 2. Okay.
All right. So yeah, I just want to make sure Ms. Lopez has a working knowledge of what's being alleged this morning. I guess ask her, does she have any testimony or evidence she wants me to consider, I guess, in opposition to the allegations that she's in violation or that she doesn't need permits or anything like that?
Si tienes testimonio o algo que quieres que considere en parte de usted.
Que me dé tiempo para sacar los permisos. Ya los tengo en trámite ya, pero no sabía que esto ocupaba permiso ni tampoco esos 2.
Okay.
Esto sí ya lo tengo ya para la construcción.
Okay.
Y esto también.
Okay.
Si me da un permiso voy a preguntar ahí.
Okay. She's just asking for additional time. I guess to her understanding, she didn't realize that all these other storage sheds and carports and small structures also required permits and required to be moved. She said that she has put an application in for the building. If you're looking at Exhibit 1, that main building there in the back. I don't know if that's the primary structure or not, but she said she put in an application in for that, not knowing that she needed applications and permits for all the other stuff. So she just requests just additional time.
Yeah, so I'm looking at the survey that was attached that you have in the packet. So is it shows the pole barn being outside of the front setback. Does show maybe that's the carport with the brick pavers being in the setback.
So from the direction of where, like if you're looking at it, the way that it's stapled, the pictures are taken from the right-hand side. That roadway, the carport that I'm referring to with the green roof is actually in front of that. It's not shown on this survey.
Oh, okay.
The back, one that says labeled as brick pavers, that one is not in the rear setback from, or it looks to be in the, everything that's on this survey is not actually where it is on the property. That's probably the easiest way to describe that. A lot of it has been moved and changed.
Okay, so
that pole barn
this was a
wasn't-
snapshot of the property and the improvements at the time the survey was provided, but since that time, the claim is that the things have either been added or moved.
Correct, yes, sir.
Okay. Is anything currently in this location? I would
The
assume that
tiny
maybe the
home, I believe, is the
that's on the
only thing
foundation?
that's highlighted yellow.
Yes.
That I believe is the only thing that's actually in the spot that it's supposed to be in. That pole barn that's labeled there with wood, there's no wood deck anymore. The
shed that's under
shed under the pole barn is not there anymore. I think that might have been the one that got moved to the opposite side of the property. And then that pole barn was then enclosed to make a living area for the tiny home that they got approved there. Is the way that it appears on site.
So I guess I would like to just confirm with Ms. Lopez, but just because of part of the language barrier, but even those who don't have a language barrier, it's difficult to navigate through the county's processes. So does she understand, you know, what she needs to do, or, you know, because it sounds like she or somebody got the approval for the tiny home. Now we have these other issues that have cropped up that she needs to get resolved. So she understands what she needs to do.
Si entiendes lo que tienes que hacer con todas las estructuras y todo.
Sí.
Una opción sería agarrar los permisos y la otra sería moverlas de la propiedad.
And how much time is Ms. Lopez requesting to try to obtain either approval or definitive answer on where she needs, what she can do or not do related to the accessory structures, the carport, the pole barn, and the I guess connector or walkway that they're looking? How much time is she requesting?
¿Cuánto tiempo necesitas para obtener todo y mover todas las cosas?
90 días. O en lo que tardan, porque tengo un mes de estar esperando los permisos.
She's requesting 90 days. She doesn't really know. Says she submitted it about a month ago, and I don't think she's heard back or from the planning department, or maybe she doesn't understand where she needs to go from there.
All right. Is there, Officer Neenan, I know you may not have been able to walk the property, but based on your investigation, are there any health, safety, or welfare issues that the county's concerned about that would maybe require that we not give the full 90 days? Because I am inclined to give that unless there's something that I'm missing.
I don't believe so. There's a septic on site. There is a bathroom in the tiny home. I don't think there's any safety or welfare, like health issues that would be on the property. It's fully fenced in as well.
Does the county have any comment one way or the other on the requested 90 days from Ms. Lopez?
No, sir, we do not object.
Okay. All right. I guess let Ms. Lopez know that I'm inclined to give the 90-day that she's requesting to bring the property into compliance. Ask her if there's anything else she wants me to consider this morning.
Si hay otra cosa que quieres que considere.
No. Okay. All right. Thank you.
Thank you.
Gracias.
All right, we'll close the evidence portion of this hearing. Before I do that, what's the county recommending if we do give the 90 days? What type of fine is the county requesting should the property not be brought into compliance within that time period?
My original recommendation was 30 days to achieve compliance or $250 per day fine to accrue with a $73 admin fee.
All right, thank you, ma'am. All right, I'll, at this time, close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 245 East Violet Lane in Defuniak Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that there has been sufficient evidence and testimony to show that a violation has occurred at the property, specifically a violation of 1.13.00A, development approval, 1.13.09C, building permit requirements. Based on the request of the property owner and without objection from the county, I will provide that the property must be brought into compliance within 90 days. That's July 7th, correct? All right. So the property need to be brought into compliance on or before July 7th, 2026. In the event the property is not brought into compliance on or before that date, a $250 per day fine will be imposed. In addition to the fine, there's $73 in administrative fees. That'll need to be paid within 30 days, regardless of whether or not the property is brought into compliance on the time provided. Can you make sure Ms. Lopez understands that?
Señora López, te va a dar los 90 días, que sería hasta el 7 de julio. Y si no tienes todo lo que necesitas para el tiempo que te da, va a ser $250 dólares de multa por día después de esa fecha. Y hay $73 de una multa que debes por la oficina, todo el papeleo que tenemos que hacer. Los 73 se tienen que pagar como quiera. Se paga en el courthouse. Ajá.
All right. All right. All right. I believe that concludes that case. And Ms. Lopez, best of luck to you. All right. Thank you. All right, our next case is CE 260042. Property owner is listed as Richard Blaine, B-L-A-N-E. Is Mr. Blaine here or somebody on behalf? All right. And are you Mr. Blaine? All right. And Mr. Blaine, we'll do yours just like we've been doing the others. I'll let the county present, and then you'll have an opportunity to ask questions or present any evidence. All right, Officer Neenan, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regard to case number 26-00042. The property is located at 9538 County Highway 183 South, Ponce de Leon, Florida, 32455. Property owner listed as Richard Blaine. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 2.02.00P RVs, 5.0709C non-operating vehicles, junk and debris, 7.02.03 dilapidated structures, and Florida Statute 515.29 pool regulations. On January 26th of 2026, our office received a complaint stating that there is junk and debris in non-operating vehicles and people living in RVs. On January 28th of 2026, I conducted an initial inspection and found that the front fence had fallen down and there's junk and debris throughout the property, RV living, a mobile home on the left side of the property with a tarp over the roof, inoperable vehicles on the left side of the property in front of the fence, and no fence around the pool in the front of the primary mobile home. On January 28th of 2026, a notice of violation was given as prescribed by code. At this time, no contact has been made with the property owner, but notices have been removed off the property. On February 23rd of 2026, I conducted a follow-up inspection and found that the property owners are working to fix the dilapidated fence, and the junk and debris and inoperable vehicles were still present on the property, as well as the dilapidated mobile home and RV are still on the property. On March 19th of 2026, a notice of hearing was given as prescribed by code. As of yesterday, the inoperable vehicles that were along the front fence line, those have been removed, but the unpermitted, dilapidated mobile home is still on the property, RV is still on the property, and junk and debris throughout. Photos in your packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
That'll be accepted in evidence. Mr. Blaine, do you have any questions for Officer Neenan? And do you have a copy of the packet? Okay, good. Do you have any questions for Officer Neenan or?
The RV is.
Hold on. Yes, sir. If you don't mind, if you'll come on up to the podium. The first thing is, do you have any questions specifically for Officer Neenan? If not, I'll have her sit down and then I'll let you testify.
We need more time.
Yeah. So now's your opportunity. I'll be glad to hear. It sounds like you're working to rectify some issues.
Hard as I can.
Yes, sir. So do you have any any evidence or testimony you want me to present, or are you just here asking for additional time?
Additional time.
Okay. How much time do you think you'll need, sir?
About 60, 90 days.
Okay. And you understand what do you have an understanding of what you need to do to bring the property into compliance? I know that Officer Neenan testified she hasn't had any contact with you, but do you feel like I mean, I would recommend you speak with her or somebody at code to make sure you're doing what you think you need. I mean, sometimes you have property owners, they think they've done what they're supposed to do, and then they find out later, oh, you didn't do this part as well. So right now, what we have is the RV requirement. Officer Neenan, I mean, he's testifying that there's nobody living in any of the RVs?
I hooked everything to it.
Okay. And then we have non-operating vehicles, junk and debris, dilapidated structures, as well as the pool regulations. And I just wanted to make sure I was pulling that up as Officer Neenan was providing testimony. That's if you have a pool, you have to have fencing up around it,
Got a
barriers.
fence around it when I put it up there.
Right, but it's got to meet certain legal requirements. So I think that may be part of the issue. Officer Neenan, can you clarify on the RV? He's claiming nobody's living in there.
It appeared that people were living in it, the slide outs were out, the stairs were down. I mean, if I'm allowed on the property to see that there's no one living in it, then we can handle that
Right.
violation.
And then as far as the vehicles, junk and debris, Mr. Blaine, do you have a pretty good grasp of what you believe the county's?
Yes, I'm trying to get rid of all of them.
Okay. Well, that should resolve it if you get rid of all of it. I don't,
Trying to haul 1 or 2 off a week.
the dilapidated structures, is that just or what is that specifically in the county's eyes? Is that the mobile home that's out there?
It's an unpermitted mobile home that is on the right-hand side of the property. It has a blue tarp over the top of it.
The one that's in Exhibit 4, the photograph?
Correct, yes, sir.
Okay.
It would either need to be structurally sound and permitted or removed off the property.
And Mr. Blaine, is that a mobile home being used currently?
Just for storage.
Okay. Well, you hear from the county, they're alleging that needs to be permitted. If you're gonna keep it there, whether it be for storage or something else. I don't even know that you can use it for storage.
You can't use a mobile home for storage and according to land development code. That would be a question for the planning department.
So it sounds like if you could get a permit to rehab that and actually use it as a living quarters, you'd have to get that approved through planning. I can't authorize that or anything, and neither can Officer Neenan, but if you want to explore that, you can definitely explore that with the planning department, and they can walk you through that process if it's available to you. So we talked about that, and then Mr. Blaine stated or testified that he does have fencing up around the pool. Is it that the fencing's inadequate under Florida statute?
Yes, sir.
Okay.
It's very hard to see from the pictures. It's easier to see when you're out on site because it's a chain link fence, and a picture just doesn't quite show. Because it does look like the fence doesn't go all the way to the house to where it has to be completely enclosed to alleviate anybody from being able to enter in from, or, secured.
All the way around it.
Does it goes all the way to the fence here? Because it looked like the fence had fell down on this side.
It goes.
Okay, that would be something that I would need to also observe while being onto the property, because it did appear from the other side that it did not go completely all the way around to where there was a secured gates. Not only that, I don't believe it has any self-locking gates, which is also, it's also required by code.
Okay.
Building code.
Blaine, do you have is it self-locking?
Yeah.
Like I said, it's pretty strict and specific in the law as to what you're allowed to, like what kind of barriers or fencing you're required to put up. So if you don't have that, then you probably better to get with the county to make sure you're in compliance. All right, so I guess at this point Mr. Blaine, you don't necessarily deny the violations, you're just asking for some additional time to bring everything into compliance. Okay. And that's, I understand that. All right, anything else that you want me to consider? All right, thank you, sir. You can grab a seat. Officer Nina, what's the county requesting should a violation be found?
Just due with the lack of communication with the property owner, I recommended 30 days to achieve compliance and a $250 per day fine to accrue with a $73 admin fee. And also, I'm going to hand them my phone number and my name on a sticky note so that they can try to contact me so that I can come onto the property to view the ones that they are alleging are not violations.
All right, thank you both. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 9538 County Highway 183 South, Ponce de Leon, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I do find that conditions presently exist on the property to show there are violations of the Walton County Land Development Code, specifically 5.07.09C, exterior storage of non-operating vehicles, junk and debris, 2.02.00P, recreational vehicles. I understand Mr. Blaine's testimony is that there's no one living there, and that he's disconnected and resolved those issues, but I'm gonna find there was a violation, and we just need to have the county come out and confirm what you've testified to, Mr. Blaine. As well as 7.02.03, dilapidated structures, specifically the mobile home that's in the photograph that has the blue tarp on it. I don't believe there's been any evidence of any other dilapidated structures that would fall under that. And then lastly, we have the requirement for, I guess, fencing around pools. Mr. Blaine's testified that he does have fencing, but did admit that he doesn't have the self-locking gates. So, Mr. Blaine, I'm going to find that there's that violation, but that may be resolved similar to the RV should you show that you're in compliance with state law. So with that being said, I know the county has requested 30 days to bring the property into compliance. I'm going to provide Mr. Blaine somewhat split the baby. What's 75 days out? All right. So, Mr. Blaine, I'm going to require that you bring the property on or into compliance on or before, you said the 22nd? June 22nd, 2026. In the event the property is not brought into compliance on or before June 22nd, a $250 per day fine will be imposed. So if you bring the property into compliance on June 21st, then there's no fine. The only time the fine accumulates is if we roll over and there's some violations. And I don't know if you were here earlier, but in the event you go too far, right? Say it takes you 90 days. You can always come back, have them come out, confirm everything's been resolved, and then seek a fine reduction. And that can be considered. But at this time, you'll have till the 22nd to bring the property into compliance, or a $250 per day fine shall be imposed. In addition to the fine, there's a $73 administrative fee. That'll need to be paid regardless of whether or not you bring the property into compliance, and that'll need to be paid in the next 30 days. You'll pay that through the clerk's office. Don't try to pay that today, because they're not going to have it in the system. Give it a day or two. Do you have any questions regarding the time or the what you need to do? All right. All right. Mr. Blaine, I appreciate you showing up. Good luck to you, sir. All right. We've been going for an hour and a half. Are we good to keep going, or do we want to take a quick break? I mean, I'm good to go if everybody else is good to go. All right. And so our next case that I have is number 10 on the agenda. This is property of Sean Myrick and Christina Jones. Case number is 260046. Are you Mr. Myrick?
I am.
All right. All right, Officer Neenan, this is your case, whenever you're ready.
For the record, I'm Officer Rachel Neenan, Walton County Code Compliance. I'm submitting my final summary case report and testimony in regards to case number 26-00046. This property is located at 24 Blime Lane, number 7, Santa Rosa Beach, Florida, 32459. Property owners Sean Myrick and Christina Jones. This property is in the unincorporated area of Walton County and is subject to the Land Development Code, Chapter 7, and county ordinances. The violations cited are 1.13.06 post-permit changes. The complaint, our office received a complaint on January 27th of 2026 about pavers being put down with no permit. On January 28th of 2026, I conducted an initial inspection and found that the whole front yard has had pavers laid down. And I approached the door and spoke to the property owner through the Ring doorbell, and I explained to him that he would need approval through the planning department to have the pavers. I also issued a notice of violation as prescribed by code on that date. Email correspondence was exchanged between the property owner and the planning department and engineering, but the property owner did not remove or apply for approval for the pavers as of today. On March 19th of 2026, a notice of hearing was given as prescribed by code. And at this time, no correspondence has been achieved since February 28th of 2026 that I have been notified of. Photos in the packet show the initial inspection and pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right. I'll accept that packet into evidence. Does Mr. Myrick, you have a copy of that?
I do, and I got one question for her.
Okay, yeah. Are you done, Officer Neenan, as far as your testimony? Yeah, if you've got a question, go ahead.
Yeah, she stated that she hadn't heard anything from February, and it shows even in her case report that on 3/5 she was forwarded an email that I had sent to planning. I just wanted to make sure that was there. On 3/2.
So is your question, did she receive an email from you on March 2nd?
She wouldn't have gotten it from me. I didn't copy her. I just sent it to Paula Mazan. I just wanted to make sure that she had that in her document.
Do we have that?
I stand corrected.
Okay. Yeah, I mean, I have emails.
I think the date of the email was actually 3/28. I mean,
Yeah,
2/28, but
2/28, I see
I
an
wasn't in the office on that day, so I notated that I actually read the email on March 2nd. That was when I would return back to work.
Okay. Right. And this email
Is in your
from
packet,
from
yeah.
Mr. Myrick, and it was addressed to Miss Ward, Paula Mazan, and you were carbon copied on it. Okay.
Correct, yes, sir.
Yeah, we have that in there. It's Exhibit 13 if you're looking for. Any other questions for Officer Neat? Okay, great. All right. All right, Mr. Myrick, any testimony evidence you want me to consider?
I do. I have a binder for you if you'd like to look at it. It's a timeline summary of all my interactions with planning, engineering, and Rachel, but she got most of those lined out. It also has some pictures, the actual plan that I submitted to
Okay.
planning and engineering.
Yeah, if you don't mind, show a copy to the county. Okay. That's fine, and I'll be glad to put that into evidence as Respondents Exhibit A.
Okay.
And we'll make the report from the county's Exhibit 1. All right, and if you want to go ahead and hand me the binder, I'll take that while you present testimony. All right, thank you, sir. All right, whenever you're ready, Mr. Myrick.
Okay. My name's Sean Myrick. I've been working diligently with the county for over 60 days to resolve this case, but I haven't really been given clear instructions on how to move forward. My primary goal since the first time I heard from Rachel was to get it resolved, but I've been having trouble getting guidance from planning and engineering. I initially installed the pavers as a safety measure. This wasn't for cosmetic reasons. Our neighborhood floods pretty bad. We've reported it through the county several times to get it resolved, but what it works out to is the neighborhood was built in a swamp in '84, and then a bunch of neighborhoods got built up around us. So we have a very bad flooding problem, to where, pretty much all of the yards are at least 12 inches lower than the actual street, and there's nowhere for the water to go. So I installed pavers up to my door, slanted down and away from my neighbors, the one that complained. I sloped them away from her property. When I got this notice, I inquired on how to do it. I was given issues about ICR or ISRs, and this didn't really apply to my house because of the yard being so small and it being a townhome. So that's when I got involved with Andrea Ward and engineering. And basically she was citing the Land Development Code 05602, and it requiring that the drainage not exceed that is noted in the stormwater plan, of which they couldn't find, and suggested that there may not have been one since 1984. And I got an email from Andrea on, I want to say it was February 17th, stating that in the absence of that, basically it was up to my HOA, which I already had approval through, and it was my responsibility not to negatively impact her properties. So my next goal was then to find out, how do I determine that?
Hold on one second.
Yes, sir.
You said there's an email February 18th?
Yes, sir.
All right, hold on one second.
It's in that big long one. You just have to go backwards through it. Yeah, the February 18th was one by itself. That was just to Rachel.
Okay. Oh, I
It's
have
just a-
one, I see one email in your binder that's, looks like Ms. Ward wrote that based on the lack of clarity regarding the intent of the stormwater management for this area, you will need to seek the approval. They are responsible for oversight based on the streets, easements being private. This is a responsibility on your behalf not to burden your neighbor with additional runoff. So do you have an HOA?
We do.
Okay. And I'm guessing that the complaint came in due to the runoff from the neighbor, or did we get this complaint get issued from someone else?
It came from my neighbor.
Okay.
I'm on the board for our HOA.
That's fine. I'm just making sure I have it in context or
No problem.
a clear picture. So go ahead. Yeah, I found the email you were talking.
Okay, so I got that email back from her on the 17th, and I thought that we were on a clear track of being able to get it resolved. And I reached out to Rachel. She said that I have to go through planning, so I contacted Paula Mazan on a Friday. I believe it was the 18th or 19th. Yeah, 19th. I called and got a hold of Paula, and we chatted for about 17 minutes per my cell records. And we went back and forth about what we needed to do. And she says that it's still up to Andrea, that Andrea was the one that would have to provide the guidance on this. And I requested to start the permitting process so that I could get it going. And she said to hold off until Andrea answered, because I may not even need one. So I looked into a few things, and I think on the 25th, there was a bunch of back and forth between me and Andrea, and trying to find out the details of what I need to abide by. And, you know, eventually we got down to her saying that I need to get an engineer to basically prove that it doesn't exceed our original stormwater plan that doesn't exist. So understanding that getting a PE out there to look at this is cost prohibitive, I suggested that I would just remove most of the pavers and plant grass. And that's what I sent on the 25th, or the 28th of February. And I hadn't heard anything back over a week, so I called up, I talked to Paula Mazan. She had no recollection of the email, so I sent it to her again per her recommendation, and then she said she would follow up with Andrea. And that's the last I've heard of it until I got home from Panama on April 3rd with a certified letter in my house that my dog sitter signed for.
So yeah, the last string of emails for both you as well as the county appears to be these from the end of February, where you're going back and forth with Andrea and Paula, and what you just testified to about the proposal where you say, well, you'll have the current layout or is original layout 374 square feet of driveway walkway, current layout 271 square feet of added impervious surface in the front area, and then the proposed layout, which I guess would be what you just mentioned or testified to, is 160 square feet, and then making the rest, I guess, natural or grass to minimum, or I guess reduce even further the impervious surface. And you don't have any, you didn't receive any response to this last email from February 28th?
No, well, I re-forwarded it on March 5th, and I didn't receive anything from that one either. I sent 3 follow-up emails while I was out of town, but they didn't go out, unfortunately.
All right. The
I basically just want to know what I need to do. That's it. And I've been trying really hard to find out.
Yeah, that was going to be one of my questions, was a stormwater plan approved, but it doesn't sound like the county or yourself have been able to find an approved stormwater plan for that subdivision.
They found one, but it was for Winston Townhomes in Inlet Beach. And I pointed that out after it'd been about a week since Shauna sent it to Andrea, and I was trying to get movement on it because I was going out of the country and I needed to get it taken care of before the compliance date.
Understood. Officer Neenan, do you have any questions for Mr. Myrick? All right. Have you had any contact with either, I guess, Andrea Ward or Paula regarding this matter?
I actually did send my own follow-up email, and because I printed the last one that was from him, and it wasn't my response, I asked for a status update as well on the response to this email. I've spoken to Paula about it, and she said that, you know, Andrea would be the one that would need to answer his questions. I believe that was told the same information that Mr. Myrick was.
Well, I mean, I guess, is it, Mr. Myrick, you don't contend that you did post-permit changes and modified, I guess, the driveway area? Was it just like concrete slab driveway, standard driveway, similar to what your neighbor has in the photographs?
It was smaller than what she has. She widened her driveway by about 6 feet. Mine was the standard one that was installed with the regular houses. 10 of the other 16 units that are in the house have all installed double driveways. Some of them have completely bricked in their entire front yards. Even the other side of my neighbor that complained, they only have about 36 feet of impermeable surface in their front yard. So this isn't anything, this is what our HOA suggests to do because of the issue. Because, you know, if it rains, if we get a couple inches of rain, I'm walking through 8 inches of water to get to my car.
I can testify that that is correct information, that it does flood there.
Yeah, I see the
really, really
photos.
bad. It goes all the way to their door, the bottom of their door.
Yeah, I mean, and I'm not faulting Mr. Myrick or anybody else who's trying to, you know, mitigate and preserve their property as best they can, but I also understand, you know, the nature of not shifting that water or that burden on to your neighbors, and I'm assuming that's what prompted the complaint. And I understand that other property owners may have done this in your neighborhood or throughout the county. Doesn't necessarily make it right.
Understood.
Doesn't mean that, you know, but they just haven't had a complaint against them at this point. So I guess my thing is, I'm with Mr. Myrick in the sense that, I mean, I think there's evidence, and by his own admissions, you know, evidence that there has been post-permit changes. I don't think that's in dispute, but I think what we're all looking for is what's the path forward for Mr. Myrick? Does he have to pay for an engineer to come out there? I mean, you know, logically, it would seem like if you're reducing the impervious surface, it's going to be better. But again, I'm not an engineer. I don't know how those models work and whatnot. But and I'm unsure if Mr. Myrick's email, you know, I would like, as I said, I'm sympathetic and would like to at least have some finality from Andrea or Paula. I'm assuming it might be Andrea who's the one that will actually have to make the final determination. But to find out, is he going to be required to get that engineer to come out and confirm and do the testing on or model for the impervious surface and the stormwater? And I know that's a problem, especially in the south end, you know, throughout for stormwater, right? I think for years, it was like first one to build, you just shed it off to everybody else and they deal with it when they want to build. I think we've gotten better, but it's also gotten more expensive because of that, because everybody needs to be able to deal with their own stormwater unless there's a community-wide stormwater plan in place and that's been approved by the county. So I don't want to push this off. I do think there's enough evidence presented, but I also want to give Mr. Myrick a chance to try to figure out the path forward, right?
I intend to go see a BPR manager with him after this. And we're going to get some answers, hopefully today.
So what I'm going to do is this, or what I'm leaning towards doing is this. I can give up to 90 days, Mr. Myrick. I will try to give, you know, my intent is at this point, based on the testimony evidence, I'm leaning towards finding a violation, giving you your 90 days to try to get some guidance and figure out where you need to be, whether that's, you know, restoration of what was originally there versus, you know, having an engineer come out and confirm what probably both you and I think is, if you've reduced the impervious surface, it's probably better overall. But, you know, that's not for me to decide today. But give you that time. I mean, what are your thoughts on that? As far as that goes, giving you the maximum amount of time I can.
No, that's fine.
To try to give you and have you get a path forward.
Sure, sure. My main thing is when talking with Andrea, who, you know, planning kept pushing towards, I got the feeling that she didn't want to make a decision on it. And I understand that because there is no clear cut, from what I can tell and from what she was giving me, there's no clear cut guidance in the land development code. But reading through the land development code, there is a way that they can apply administrative discretion in situations like this. And that's all I'm asking for, is if they would just review my my proposal, which, you know, narrows my yard down to less than a double driveway, which is what I was going for. But I removed as much as I possibly could and make it still look nice.
Yeah, no, I understand, and I think that's admirable. I know everybody looks like in that community's dealing with that common problem of the flooding. Everybody's trying to, you know, protect their property, which, again, you know, I'm not going to fault anybody for doing that. So, all right. Is there anything else from the county or from you, Mr. Myrick? And okay, great. Thank you. You can both sit down.
Thanks.
I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that based on the testimony and evidence presented, and Gina, make sure you grab that for the record. Based on the testimony and evidence presented, I will find that the property located at 24, is that Blenheim Lane 7, Santa Rosa Beach, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that the testimony and evidence presented does show that the current conditions presently exist on the property, showing a violation of the Walton County Land Development Code, specifically 1.13.06 post-permit changes. I'm going to provide the maximum amount of time I'm allowed. That's July 7th to bring the property into compliance. What's the county requesting as far as a fine goes? Okay, I'm going to make it $100 per day. So you'll have until July 7th. Hopefully you'll have a path forward well before that time to bring the property into compliance. In the event the property is not brought into compliance, a $100 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That'll need to be paid regardless of whether or not the property is brought into compliance. You'll have 30 days to pay that $73. And Mr. Myrick, I believe you were here earlier, but just in case, you know, obviously work with the county. It seems like you've been attempting to do that. So I know sometimes it may be frustrating and you don't get the answers as quickly as you'd hope, but I know they're busy as well. But hopefully with Officer Neenan's help, you'll get a clear path forward. But what I was getting at is, should you go past the July 7th, you can always come back and ask for a fine reduction, assuming one is even needed. So any questions regarding the order? All right. All right. Thank you, Mr. Myrick, and good luck to you, sir. All right. Our next case is 25-1928. Property owner is listed as Julie English, and its property address is 199 Ruckle Drive in Defuniak Springs, Florida. Good morning.
I'm Code Officer Sarah Madrano, presenting case number 25-01928. The owner is Julie English.
All right, which one do you use, Miss English? All right. Yeah, if you want to grab a seat, do you need to be, what we'll do is we'll let the county present, and then I'll hear from you, Miss English, or, any testimony or evidence you wish to present. All right, and I'm sorry, what officer?
I'm Sarah Madrano.
Okay.
The violations that are cited is 5.07.09C, junk and debris, and then 7.02.02 for overgrowth.
All right.
A complaint regarding conditions on the property was received on November 20th, 2025. Code Officer Rachel Neenan conducted the initial inspection the same day and observed junk and debris on the site. A notice of violation was posted on the property on December 5th, 2025. The case was reassigned to me on February 4th, 2026, at which time I conducted my initial inspection and confirmed the violations were still present. On February 12th, 2026, I hand-delivered an updated notice of violation, which included an additional violation for overgrowth to Mr. Randolph, who is a resident at the home. I educated him on the violations and steps required to correct them. When I was at the property, I observed a disabled vehicle, a utility trailer overfilled with debris, and oil containers in the yard. On March 13th, 2026, I hand-delivered a notice of hearing to Miss Amanda Anderson, the homeowner's daughter and resident of the house. The violations remained unresolved. Photos in your packet show the initial inspection of pre-hearing conditions with violations still existing. I would like to submit my packet into evidence.
All right, that'll be accepted. So looking at the photographs, is the overgrowth related to both the yard as well as the, I guess, the bushes that are as well?
Yes, sir, and there's also vines growing on the house as well.
Oh, okay, yeah, I see those as well. All right, and then the exterior storage, junk and debris, that's related to, is that the lawnmower? I see some other things. Looks like the inspection on April 3rd shows many of those things picked up, and then the mower is on the trailer by the driveway. Would that still be considered a violation?
The violations that I observed on 4/3/2026, these photos are a little dark. There is what looks like a pool filter or something in a bush on this first picture, aiming of the property. Can't really see it in the bushes, and there's also a large tractor tire in the yard on that final inspection.
So when you're facing the home from the street, you're talking about this area right here?
Yes, sir.
Immediately adjacent to the home?
In that
Okay.
first bush adjacent to the house, there's a pool filter along with a tractor's tire with no rim in it beside that. And then those glass mirrors in front of the property.
Okay, but, so other than the three things you've listed, the pool filter, or what we believe is a pool filter, the tractor tire, and the glass mirrors, those were the only violations that you noted or documented on your final inspection on April 3rd. So we're good on the trailer and the mower being located on that adjacent, okay.
Yes,
Just
sir.
wanted to make sure. All right, and then, So the overgrowth is still present. It does look like they did do some, maintenance, regarding the bushes, as well as, I don't know that I necessarily see the vines on the third. Has the overgrowth been resolved?
They've definitely worked on the overgrowth. There's still some that needs to be resolved, but they've definitely done some work.
What would need to be resolved?
The leftover overgrowth, the pool filter, what appears to be the pool filter,
Yeah, I'm
and
just
the tractor.
Right, I'm just specific on the overgrowth. So what's left on, I guess, on the overgrowth? I got the mirrors and other things. I think that would fall under the exterior storage portion. I'm looking for overgrowth under 7.02.02. What if with Miss English is here today, what would you tell her that she would have to resolve, in your opinion, to rectify the overgrowth?
Anything over 18 inches of length for the LDC.
Okay. Well, these bushes are probably going to be over 18 in height, so those would be exempt, right? I guess before it was the bushes and the vines and whatnot, and it looks like the vines and the bushes have definitely been trimmed down. I can't see the vines on there. Maybe I'm just missing it.
There's actually weeds in the front yard, Your Honor.
Yeah, I see that.
And those are over 18 inches in growth. They just need to mow the yard. They have worked on the bushes and the vines,
Right.
but it's just mainly the yard now.
Okay, that's what I'm trying to clarify, because, I mean, I don't have a much better yard than that, but.
Especially right now with all the rain, last week.
So the only overgrowth that remains, at least in the county's eyes, is those weeds and whatnot that are peppered throughout the yard that are over 18 inches.
Yes, sir.
Okay. All right. Thank you, ma'am. Miss English, do you have any questions for Madrano? Am I saying that? Madrano? Okay. Officer Madrano at this time? Okay. All right. Miss English, do you have any evidence or testimony you want me to consider or present this morning? And if you do, you'll just need to come up here. That's fine.
I have been working on the yard since I moved back in the house.
Yeah, it looks like
it. It was bad. Like, my nephew lived there for a few years, and they did, for whatever reason, planted honeysuckles all over the house. Like, the whole house was covered in vines. And even before they came out, I had already started trimming and trying to clean my yard up. I since then have started working overnights, so I do work a lot. It has slowed down the process a little bit, which they've been awesome and great every time they came out. But it is everything. The car was my nephew's. He lost his key, so I made him turn the tag in because it wasn't in his, the tag wasn't in his name, it was in his stepmom's dad's name, so that is why the tag was off the car. We did move the car.
No, I think it's clear, and that's why I was asking the county, what needed to be resolved to try to get you across the finish line, so to speak.
And the trailer is back there, sir, because my husband, I did get him to bring it back so I could finish getting more stuff, because that's the only way I have to do it is to use my husband's trailer.
Yeah.
To get everything moved, so that's why it's back in the yard now. The trailer isn't even normally there.
Yeah, it doesn't sound like the trailer's an issue. I mean, you heard that at least from their last inspection, which was last week, they say there's maybe a pool filter or something that's in, adjacent to the home. There might be a tractor tire or some sort of tire that's out there.
There is a tractor tire. I have to
And
get help moving that, but I will get it done.
some glass mirrors out front that also need
Okay,
to be
I'll look
resolved.
into that too.
And maybe that goes in the house or behind the house, so it's not, you can't see it from the road. But it sounds to me like you're very close to being done. How much time do you think you'll need to get everything finished?
Well, I can try, I'm off tonight, so I'll try to definitely work on it some today. And now the trailer, I have to wait for my husband to come back and get that again. And there was a freezer in the yard. I did get that dumped. I did try to move it, but I couldn't dump it. I didn't know it was full of water. I could not budge
Well, do
it.
you think you could get it done in 45 days if given?
Absolutely, yes, sir.
And even the tall weeds that we were just discussing, since that photo, my husband has been out there with a weed whacker and the lawnmower we had to borrow from my dad, because ours just went out a couple months ago, so we've been borrowing from
That
him.
big one went out, or that's the one you're
No,
using?
that's the one we borrowed from my dad.
Yeah,
We
that
had a
one looks
little
like-
electric one.
Okay,
It was
that one
not
should
it.
be able to take care of it pretty quickly.
It does, yes, sir.
All right, and are you Miss Anderson?
No, that is my sister.
Oh, okay.
I would like to say, like, the mirrors and stuff, though, when y'all do talk to my sister, she is really special needs. She does not relay messages the best.
Yeah,
Like, I didn't
she's-
even know the mirrors were an issue, or we could have been handled that.
Yeah, I think that's pretty easy to
My
handle. What-
cousins did that. They said it helps with the plants or something. I don't know. It was something they did when they was there.
What's your name, just so we have? it?
Kayla Hayes.
Okay, Miss Hayes.
Mr. Randolph is my husband.
Okay, thank you, Miss Hayes. All right, so, I mean, I guess as, at least for you, Miss English, 45 days would give you plenty of time, you know, wouldn't feel like you're rushing, but you could do it.
Yes,
within
sir,
that.
absolutely.
Okay. All right, great. Do you have anything else you want me to hear? No. All right, great. You can have a seat. Thank you, ma'am.
Thank you.
All right, Officer Madrino? What's the county looking for as far as timelines and fine should they not bring the property into compliance?
Yeah, so although the property owner has never been adjudicated before, we have had multiple cases in the past with the same violations reoccurring. For this reason, I recommend 10 days to achieve compliance or a $250 day fine to accrual with a $73 admin fee.
As far as, which I understand, if you've had other complaints on the property, and if those have been resolved, then they've been resolved. But are there any health, safety, or welfare issues that I should be aware of that would warrant such a short timeline to, because it does appear that Miss English has actively been bringing the property into compliance since she's been involved. So are there any health, safety, welfare issues that I'm aware of?
Not that I observed.
Thank you, ma'am. All right. I'll close the evidence portion of the hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 199 Runkle Drive in Defuniak Springs, Florida is located in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. I'll find that based on the testimony and evidence presented, sufficient evidence has been presented that a condition or conditions exist at the property that show there is a violation of Walton County Land Development Code 5.07.09C, junk and debris, and 7.02.02, overgrowth. Over the county's objection, I'm going to provide that the property owner has 45 days to bring the property into compliance. What was that? All right, so you're actually going to get like 47 days, so that'd be May 26th, 25th. All right. So on or before May 25th, you'll need to bring the property into compliance. I would recommend to stay vigilant the way you have been, not maybe wait till the very last day, because if something happens, you get sick or something breaks down, then fines are going to accumulate. I will provide that if the property is not brought into compliance, a $250 per day fine will be imposed. So it is obviously recommended not to wait till the last minute so those fines don't start accumulating. Separate and apart from the fine and the time to bring the property in compliance, there's a $73 administrative fee. That'll need to be paid regardless of whether the property is brought into compliance, and you'll have 30 days to pay that, all right? Have any questions, Miss English, regarding the order? All right. Did I miss anything from the county? All right, great. Miss English, thanks for showing up today, and best of luck to you.
Thank you.
Yep. Our next case is CE 260020. Property owner is listed as Scott Anderson. And the address is 295 West Renoir, Renoir Road in Definiak Springs. Do we have anybody here on behalf of Mr. Anderson?
I don't see him in here today, sir.
Okay. All right, whenever you're ready.
I am Officer Sarah Madrano. On January 14th, 2026, a complaint was received regarding conditions of the property. On January 15th, 2026, Supervisor Jennifer King conducted an initial inspection on the property due to one of the allegations being chemicals were being dumped in a nearby pond. No evidence of that was observed, and the case was reassigned to Officer Knudsen. On January 29th, 2026, Officer Nikki conducted, which is Officer Knudsen, conducted an inspection and observed two vehicles totaled out on the property. This case was reassigned to me on February 4th, 2026. I conducted my initial inspection the same day and observed one totaled vehicle remaining on the property. During my inspection on February 4th, 2026, I spoke with Mr. Scott Anderson, who stated he was negotiating with the insurance company and expected the vehicle to be removed within a few days. I gave him a verbal courtesy warning. On March 6, 2026, I hand-delivered a notice of violation as the vehicle was still present on the property. Mr. Anderson explained that the vehicle was part of a legal dispute. On March 13, 2026, I hand-delivered a notice of hearing. Photos in your packet show the initial inspection, pre-hearing conditions with violations still existing. I'd like to submit my packet into evidence.
That'll be accepted. So it looks like your final inspection photograph, we're just dealing with the black truck?
Yes, sir,
Okay.
that's correct.
All right, what's the county requesting?
30 days to achieve compliance, or a $250 per day fine to accrue, and then a $73 admin fee.
Thank you, ma'am. All right, I didn't see anyone come in on Mr. Anderson's behalf. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 295 West Renoir Road, Definiak Springs, Florida, is in the unincorporated area of Walton County, Florida, and is therefore subject to the Walton County Land Development Code. Based on the testimony and evidence presented, I'll find that conditions exist on the property to show that there is a violation of the Walton County Land Development Code 7.02.01A, junk and litter. Based on the county's request, I'll provide that the property must be brought in compliance within 30 days. That will be May 30. May 8th. And the reason we pause is just to see if that's on a weekend, and we gotta move it, so that's why. In the event the property is not brought into compliance on or before May 8th, a $250 fine will be imposed. In addition to the fine, there's a $73 administrative fee. That administrative fee will need to be paid regardless of if the property is brought into compliance or not, and they'll have property owner have 30 days to pay the administrative fee. Sign that order. And then our last case is CE 26-0107. Property owner is listed as Sue Lusk, L-U-S-K, and the address is 981 Seven Oaks Road in Definiak Springs. Are you, drew the short straw, or are you Miss Lusk?
Yes.
Okay. We finally got to you. I know you're probably thinking it's never going to happen, but we did. All right. And Ms. Lusk, you were, I believe you were sworn in earlier, correct? All right. So we'll do just like we've been doing. I'll let the county present, and then I'll hear from you. All right? Whenever you're ready.
The violation cited was 5.07.09C, junk and debris. I'm Officer Sarah Madrano. On February 17th, 2026, a complaint was received regarding conditions on the property. I conducted my initial inspection on February 19th, 2026, and observed junk and debris in the front yard, along with kitchen and bathroom appliances and numerous abandoned vehicles. A notice of violation was posted on the property and mailed to the homeowner on February 23rd, 2026. A county-provided dumpster was delivered to the property February 25th, 2026. On March 3rd, 2026, I completed a follow-up inspection and observed that many vehicles had been removed and the dumpster was being utilized. After completing a follow-up inspection and finding violations were still occurring, a notice of hearing was posted on the property and mailed to the owner's residence on March 28th, 2026. On April 3rd, 2026, I conducted my pre-hearing inspection. Although most of the debris was removed, a small amount remained in what appeared to be a burn pile, along with 3 vehicles covered with a tarp. Photos in your packet show the initial inspection and pre-hearing conditions, with violations still existing. I'd like to submit my packet into evidence.
That'll be accepted in evidence. So putting the tarps over the vehicles isn't sufficient?
No, sir. And the instructions on the notice of violation, they have to screen or remove the vehicles, per the county ordinance as well.
Right, so my question was, that's not considered sufficient screening.
No,
No.
sir, the land development code says specifically says a fence or vegetation.
Okay. And then, the burn pile,
Yes, sir. There is a small burn pile right beside the dumpster. That's where the, you can see in the initial inspection where the, the large pile was. Yes, sir. There's just a little bit left there.
I don't know if they'll get a burn permit. I mean, we're in our drought for a little while, but who knows? Okay, so besides the vehicles and that's the only thing that's remaining, correct?
Yes, sir.
All right. All right, Miss Lusk, do you have any questions for Officer Madrano? Or if not, then I'll just allow you to.
Thank you.
Yeah.
Yeah, on the picture here on the 3, those are 3 trucks that are grouped together.
Yes, ma'am.
And we had discussed several weeks ago, went to the office of the code, and there were several people there in the office, and we had discussed about covering these vehicles like with tarp or with bushes, vegetation. And they agreed that that was a possibility, and I said, well, the tarp, they wear out, after a while, but the tarp covering or covering with bushes, would work. And so I discussed this with Sarah last week, whenever I saw her. I can't remember the date now. So we could cut bushes or have trees there in front of these trucks, so they're not visible from the road. But then she said that's not appropriate either to do that. The suggestion was to push them back into the woods. They're at the edge of the woods right there now, and but there's trees back there and stuff, so all these trees would have to be cut down, and I think they'd probably still be visible from the road. Actually, they'd have to be shoved like way, way back in the woods. So I had already covered them with tarps. The dumpster is gone. I called the county a few days ago, and they removed the dumpster. That pile there is a burn. If you can see on the side, there's some bushes there that my son has cut down. He's trimming some trees and stuff. And in that area, that's where we usually put our stuff that we're going to have burned, but we're not burning right now. But all the major construction, the stuff that was there, all that is gone now. And
Yeah, I can tell, similar to the last case, you've taken what the county said to heart, so to speak, and have started just not quite over the finish line, right? So
Yes,
just,
sir,
how long do you think it'll take you to figure out something with those vehicles and then deal with the burn pile?
Well, the burn pile, we can't burn, because it's been dry. So
Right.
we just kind of pile that up right there for the moment. But on the trucks, So with the vegetation, I guess I'm not quite clear on that. Like, we have a lot of trees we can cut down and cover them in the front, you know, and everything. But that wouldn't be appropriate either,
I
to
don't-
cover them
I
up
don't think-
like that.
But that's not my call. I
Yeah.
mean, I think if you like, try to do like what we see in the movies where they're covering up a
Yeah,
pit with
yeah.
a bunch of, I don't
Yeah.
know that that's
Yeah.
sufficient,
Yeah.
Like making a wall of vegetation, planting bushes,
like screening.
growing, but use the planting.
Oh, okay. Well, yeah, because this wasn't ever clear about, what are you talking about, vegetation, you know? Okay, so we could actually plant something there, or, but it might, okay, but it might take years for it to grow, so that's okay?
Mature ones.
Oh.
Immediately.
Okay.
But we could discuss other options. But I just wanted to also clarify that the vegetation that is stacked up, that is not a violation. It was the
Okay.
construction material
Yeah.
that was within that burn pile that constituted the violation.
So is there any more construction material?
No, sir, all that's gone.
Okay.
That's just,
Well, I mean, and the county can come back out and confirm that it's just natural vegetation that's been cut,
I
right?
believe at the last inspection, we've seen a glimpse of something out there. It did not appear to be vegetation, but
Yeah. So it sounds like you got the vehicles, and then as long as you don't have a bunch of 2x4s and plywood hidden up under all
No,
that,
sir.
those
No, sir.
tree limbs, you
No.
should be fine.
No.
Okay, well, how long would you request I mean, obviously you might want to get with, code, confirm what kind of screening would be, sufficient for the code, and then have them inspect, but what are we thinking, 30 days to bring everything into
Yes, sir,
compliance?
because right now, I just flew in from Pensacola. I have to fly back now, my grandson's in the hospital, so
Oh,
we've
no.
been spending, days and, over 2 weeks now. My daughter and son-in-law, he's the one that's got all the cars off and's been helping me with this too.
Okay,
We've all been tied up with that right now.
understood.
So on the trucks, okay. Now, they talked about a fence, but now they also mentioned it has to be up to code, so I'm still not quite sure. But if you fence this in, how's he gonna pull the trucks out without tearing the fence down?
Right, well,
Yeah.
and that's not necessarily for me to sort out today. What I'm gonna do is, I'm gonna give you some time to get with the county, discuss your options, and then pick an option, right? And
Okay.
then go forward with that.
Okay,
And I just wanna give you enough time to where you've got enough space to do those things,
Okay.
right? So, you don't have to come back for a fine reduction or anything like that, or have to come
Okay.
back and pay a big fine, hopefully. But, so, understanding everybody's got stuff going on, 30 to 45 days you think would be
yes, sir.
plenty
That'd
of
be fine.
time?
Yes,
Okay,
sir.
because it doesn't sound like you've got a whole lot left, you just got a couple
Eh,
boxes to check, and it sounds like you may
yes,
be
sir.
done. Okay, what's the county requesting as far as, time and a fine reduction, or I'm sorry,
Sir?
not fine reduction, fine, on bringing this property into compliance?
We recommend another 30 days to achieve compliance, or a $250 per day fine, with a $73 admin fee.
Thank you. All right, anything else from you, Ms. Lusk?
No, sir,
All
that's
right,
it. Thank you,
I
sir.
appreciate it. Yep, thank you. You can grab a seat. I'll close the evidence portion of this hearing. I'll make the following findings of fact and conclusions of law. I'll find that the property located at 981 Seven Oaks Road in Defeniak Springs, Florida, is in the unincorporated area of Walton County, Florida, is therefore subject to the Walton County Land Development Code. I'll make, based on the testimony and evidence presented, I'll find that conditions presently exist on the property to show that a violation has occurred, specifically a violation of 5.07.09C, junk and debris. I know the county, both the county as well as the proper owner, Ms. Lusk, believe that the property can be brought in compliance within the next 30 days. I'm going to give you a little extra time, make it 45 days. I guess it's 47 days. May May 25th of 2026. In the event you don't bring the property into compliance on or before May 25th, 2026, Ms. Luss, the $250 per day fine will be imposed. In addition to the fine, there's a $73 administrative fee. That administrative fee will need to be paid regardless of whether the property is brought into compliance. That's $73. You'll have 30 days to pay that. All right? Any questions, Ms. Luss, regarding the order? All right. Best of luck to you, ma'am. Thank you. All right. All right. And I've got some orders to sign over here. I'll do those offline. And that concludes what we got, so we're adjourned.